we are getting sued. And I said, really? For what? I am in poor health. Really? That's it, right? The case is over. Not so fast. He did not make a formal request of the court. All he did was send an email. And this is what he said. Now, this is where things get interesting.
Audio.
Well, hello everybody, and welcome back to Buckle Up, It's the Law, with your host, the DUI Guy Plus. Folks, today we are going to be finally doing our comeback video. It has been a very, very long time since I have been on my channel. I do apologize for not making content, but sometimes life gets in the way. Sometimes life requires you to be present, and other things kind of have to be put back on the back burner. But I know I haven't seen you in a very long time, and I am ready to get back into the swing of things full force. Now, as you all can see, we are almost done with our new studio. The setup is essentially complete. We have most of our items already here. They have arrived. The only thing that I'm primarily missing, as you can see, is the bookshelf. That's why the books are still on the floor and stacked on top of each other. But hopefully that will be fixed up very, very soon. Now, today, I want to talk to you all about something that I know you all have been waiting a very long time for me to talk about, and that is the Lynette Preston versus me, Jeremy, George, and DJ Radis. The lawsuit that Bruce Matskin, using Scott Stark as a conduit to come after us for a bogus allegation, something that Bruce himself in multiple videos admitted we are simply using this as an opportunity to try and get Mr. Forman to talk about my macaroni and cheese case because he refused to talk about it, and to this day he will not do so. And they withdrew the lawsuit on December 26, 2024. It was the best, even though I don't celebrate Christmas, I can tell you that was probably the best Christmas gift that I have ever received. Sure, it was a day late, but you know what? I am not going to be dinging Brucey a little too much over it. So let's talk about what has happened over the past 4 months with respect to the lawsuit. First and foremost, the lawsuit was initially filed when Chandler and I were in Europe, if you all remember. At the end of August, I remember we were in, I think, St. Peter's Square, and I got a call from Jeremy Hales, and Jeremy said, hey, Larry, we are getting sued. And I said, really? For what? It turns out that Bruce alleged that we are not permitted to use Lynette Preston's image for the thumbnails. Yes, the same image that I'm using for this thumbnail. I don't think the law has been broken. To this day, I don't think any laws were violated. No laws were broken civilly or criminally, and therefore I am continuing to maintain that we can use them. Bruce has no argument. And not only that, Bruce himself admitted that he has no case by withdrawing the lawsuit. He got Scott Stark to dismiss the civil lawsuit, as I said, on December 26, 2024. That's it, right? The case is over. Not so fast. On September 18th, 2024, after waiting the requisite 21-day safe harbor period. What does that mean? The safe harbor period requires that before you sanction an attorney for improper conduct, you have to give them 21 days to correct the issue before you actually file your motion for sanctions. This is required by law. So our attorneys, Randy Shockett and Doreen Inkleys, filed the motion on behalf of me, Jeremy, George, and DJ Radis, saying, hey, this is at the end of August. Withdraw the lawsuit and we will leave you alone. Easy, right? No harm, no foul. Withdraw the lawsuit. We know it's bogus. You know it's bogus. Just withdraw it and we'll call it a day. They failed to do so. They were given 3 weeks to do so. The law requires 21 days. That's called the safe harbor period. So 21 days later, on September 18th, 2024, we filed our motion for sanctions. The law was very clear. In determining whether a party is entitled to statutory attorney's fees under Florida Statute 57.105, which is the sanctions statute, frivolousness is determined when the claim or defense was initially filed. If the claim or defense is not initially frivolous, the court must then determine whether the claim or defense became frivolous after it was filed. And in this case, wherefore, Jeremy Hales and Larry Forman respectfully request that the court enter an order granting the motion for sanctions, ruling that Preston or her counsel knew or should have known that the claims asserted against Jeremy Hales herein are baseless and without merit under Florida law, and thus untenable and patently frivolous, imposing sanctions against Preston and or her counsel jointly and severally pursuant to the statute. And of course, there is also the original complaint attached and the case law that supports the fact that this lawsuit is completely baseless. Tons of law tubers and other YouTubers have already covered this part of the motion. Check out Megan Fox Writer. Go check out That Umbrella Guy. They all have videos on this topic going back to September of 2024 when this was initially filed. Now, that brings us to December 26th, when the lawsuit was dismissed, about a month ago. Here's the problem. You can't file a frivolous lawsuit with no merit, no justification, no basis in law, and no basis in fact, force the other party to hire and pay for attorneys to represent them, for us to shell out money to pay Randy and Doreen to represent us, and then say, you know what, forget about it, dismissed, let's call it a day, let's forget about it. You can't do that. And that is why we had a court date that was originally scheduled for February 5th, 2025, in about a couple of weeks from now, where we were going to go to court, and originally it was scheduled to be a motion for summary judgment, which simply means to dismiss the case because it's completely baseless and meritless. Now, like I said, Scott beat us to it. Bruce beat us to it. They dismissed the case. So we no longer need the February 5th date for those purposes. So about a week ago, Randy requested from the court that a hearing be scheduled for February the 5th, 2025, to address the motion for sanctions against Stark and Preston. So in January, Randy filed an official motion requesting that Scott Stark appear to address the motion for sanctions on February 5th, 2025 at 1:15 p.m. in the Levy County Courthouse. That motion has been filed. That hearing has been scheduled in front of Judge Davis. And it was really funny because about a week ago, January the 17th, I recall seeing some posts on the internet where Brucey tried to say that this is not going to happen, that the case is over, but I don't think he quite understood the fact that there are still outstanding motions that have not been resolved. He's trying to run away from the simple fact that Scott and Michelle, and vicariously through both of them, he himself, are all liable for the misconduct that brought us into litigation. Remember, we never filed the lawsuit. We are the defendants in this case. Me, Jeremy George, and DJ Radis. They're the plaintiffs. They're the ones bringing forth the lawsuit. And now they just want to run away saying, you know, I'm sorry, we made a mistake. We don't mean to. Not so fast. That is not how it works. You can't just file frivolous litigation and then expect for everything to be smoothed out. Now, this is where things get interesting. On January 17th, the official request for a hearing for the motion for sanctions was filed and accepted by the court. Then, on January 20th, just this past week, on Martin Luther King Day, of all days, our lawyer, Randy Shockett, and his co-counsel, Doreen Inclease, filed a request for deposition to depose Scott Stark himself. Now, that is scheduled for Monday, January 27th, tomorrow. In response to that request to depose Scott Stark, he wrote an email to the Levy County Clerk's office. He did not follow proper protocol of filing a motion like you are supposed to. He did not make a formal request of the court as of this recording. All he did was send an email, and this is what he said. Dear Ms. Polk, and Ms. Polk is the clerk at the Levy County Courthouse. She's the judicial assistant to Judge Davis. Dear Ms. Polk, writes Scott Stark, I request that the hearing scheduled for February 5th in Preston versus Hales on this case number be continued. If Judge Davis feels a contested hearing on their sanctions motions is necessary, I would ask for the opportunity to file a formal written opposition by February 14th and then a hearing be scheduled thereafter. Mind you, he has had like 2 weeks to do this, and he chose to do it only after he found out that he's going to be deposed. The motions they are pursuing continuing under the sanctions is itself frivolous. Is it now? And being used to generate YouTube content. This is the angle you're choosing? Really? On numerous channels aligned with Mr. Hales. They're even subpoenaing me, says Scott, and other witnesses to testify at a deposition prior to the hearing. Scott, you are being subpoenaed because you have gotten yourself involved in something you should have never gotten yourself involved with. Now it's time to pay the piper. Buckle up, Buttercup. It's time to pay. I am in poor health. Really? The last time I spoke with your secretary, aka your wife, or paralegal, I don't know. She's a secretary one day, she's a paralegal the other day. I lose track of what her role is in your office. My apologies. I'm going based off of what she has said to me so far. A few times I spoke with her, she said you're at the gym, so you're working out. You should be in better health, I imagine. Is this an excuse? Is this another excuse? I don't know. And being subjected to the sort of litigation abuse being engaged in by Mr. Hales, Mr. Forman, and their counsel is unnecessarily stressful and burdensome. So when you filed a lawsuit against us, which was stressful and burdensome, that's okay. That's no problem. But now that we're coming after you in response to failing a frivolous lawsuit, whoa, and now it's too stressful and burdensome. Please leave me alone. Tell me how that's fair. They're engaging in protraction of litigation and multiplication of proceedings. How? You've known about this motion in August of 2024. You had 21 days, that's 3 weeks, to withdraw your frivolous claims in your frivolous lawsuit. You chose not to. You have been aware of these filings since September 18th, 2024. How long is that? October, November, December, January. That is 4 months. That is 16 going on 17 weeks that you have been aware of this motion, and suddenly you can't handle it? Please explain it to me. And multiplication of proceedings, by the way, how are we multiplying the proceedings? We are not filing a countersuit. This is just a motion for sanctions for your failure to follow the rules and filing a lawsuit that has merit. That's it. The litigation and the proceedings, goes on Mr. Stark, not their outcome, are the point because they generate fresh YouTube content for Mr. Hales. He abuses the courts for this end. Well, talk about the pot calling the kettle black. You abuse the court system and now you're blaming, I'm done. Although we believe their motion is the only frivolous filing in this case, so everything that we filed is good, but their one filing, bad. We have decided not to multiply proceedings by filing our own motion for sanctions. Well, why didn't you? That's a you problem, buddy. Directed at theirs, but instead to oppose the motion for its lack of merit. Okay, look, we all make decisions. You made yours, now it's time to sleep in the bed that you made. Thank you for your time and attention, continues Mr. Stark, and kindly let me know if February 5th will be postponed so that I may have until February 14th to file a formal response in opposition to their motion. If a hearing is necessary, I would ask the court's consideration in allowing me to attend via remote video conference, making it a much less burdensome and stressful proceeding for me to attend. He's afraid because he knows we're all going to be there. He knows there are cameras that are going to be in the room. He knows that it's time to pay, and he's scared, and he is running, and he is hiding. And I urge you, Mr. Stark, Scotty, find the courage, sir. Find the courage to come and face the consequences. I promise you, it is going to be a lot better than trying to run away from it. Face it, put it behind you, and move on with your life. That is my recommendation to you. I promise we won't bite too hard, but it is time for you to pay. These are the consequences of your actions. I would ask for some guidance, Mr. Stark continues, on whether Judge Davis feels being deposed by Attorney Shockett is warranted. So he responds to, again, in an improper fashion. He tries to get a continuance through an email, which is not the right way to do things. And then he also kind of peppers in, oh, by the way, we should ask Judge Davis if deposing me is even proper in the first place, which it absolutely is. There's no reason not to. Of course, Randy immediately replied, stating that we object to any continuance. This is not the proper method to move for a continuance under the newly revised Florida statute anyway. And the hearing has been confirmed. And of course, Ms. Polk God bless her, she replied to Scott stating that go ahead and file your motion and send us an email courtesy copy if you don't mind. That brings us to today. This recording is being made on January the 25th. I think it's going to go live on Sunday, January the 26th, if everything goes according to plan. And that means tomorrow, January 27th, is the scheduled deposition of Scotty. We'll see what happens, folks. I'm really looking forward to seeing this case continue to develop. I'm really looking forward to creating more content, not just on this. I have a lot of different plans. We have Karen Reed in the mix. I want to do a video about my grandfather. May he rest in peace. For those of you who've been following along, you may know he passed away on Christmas Day, December 25th, 2024. Just very briefly, for those of you who care, I just want to share that we were with him, and like I said, I'll be making a video separately. That he's the reason I have been gone from the tubes. My grandfather, we found out his diagnosis of stage 4 prostate cancer. I couldn't think of it for a second. My brain went somewhere else. Remembering him, stage 4 prostate cancer. We found that out when I was in Europe, when we were in Rome, actually. And I've just been focused on family ever since. So I know, by the way, I've been loving this part that Bruce took credit for the fact that I have been chased off of YouTube because of him. I find that really cute and a little bit insulting that I had to take care of family matters and he took the credit. Well, now I'm setting the record straight. The reason I've been gone, the reason for my absence is because I had to take care of family. And here we go, folks. Buckle up. It's the law. Welcome to the new studio. I hope that you love it, and I will see you all in the next video. Bye, everybody.
Audio